Hi everyone, welcome to the Commission's webinar on consultation and notification. My name is Carlin Gertzen and I'm a landowner liaison here at the Commission. I've been with the Commission for about 16 years and landowner liaison for the last approximately 7 years. Our topic today is how to effectively engage in the consultation and notification process for oil and gas activities. So just a couple of housekeeping items. Please make sure your microphones are muted and questions will be addressed at the end of the presentation. You can type them into the comments box and questions not addressed at the end will be followed up directly, or follow-up questions can also be sent to stakeholder@bcogc.ca. A link to the presentation will also be emailed to those registered and posted on the Commission's website. So this is just an outline of the webinar for today. First, we'll go through an introduction of the Commission and community relations, then types of consultation, notification, and engagement, then options to respond if you have concerns, and then how those concerns are addressed, and then information, resources, and initiatives. So first, a brief overview of who we are and how regulations apply to consultation and notification. We were established as a Crown Corporation in 1998 and authorized under the Oil and Gas Activities Act. We have 7 offices throughout BC and report to a board under the Ministry of Energy, Mines and Petroleum Resources. For the Community Relations Group, we have staff in both the Fort St. John and Dawson Creek offices. We have 2 landowner liaisons in Dawson Creek and 1 in Fort St. John. And although we're located in the Northeast, our scope of work does include all of BC, so we are not limited to just one area of the province. The Community Relations Group has a variety of responsibilities. So this includes receiving concerns from those impacted by oil and gas activities, responding to questions or concerns, and reviewing the community relations portion of applications. We offer assistance ranging from general inquiries to in-depth assistance in facilitating conflict resolution between the interested parties. We also assist the Commission in creating and enhancing working relationships between stakeholders and the public while working to ensure regulatory compliance. And these are things we do at any point or stage of an application, so it could be prior to an application, during the review stage, or even after a decision. It is important to note that the scope of what community relations does not include First Nations consultation. That is its own engagement process that the Commission does separately. So what is consultation and notification? Consultation is the exchange of information regarding proposed oil and gas activities between applicants and recipients within a consultation distance. It begins when a recipient receives an invite to consult from the applicant for a proposed project. And notification provides written information regarding proposed oil and gas activities to those recipients that are identified within the notification distance. So overall, there are 3 types of engagement that we will talk about today. It is the type of activity that the application is for that will determine what engagement will apply. So for example, if the application is for a well site or pipeline, these are oil and gas activities by definition under the Oil and Gas Activities Act, which means that the consultation and notification regulation would apply. If the application is to use water for oil and gas purposes, there are notification requirements under the Water Sustainability Act for those types of applications. And if the application is for a campsite, laydown site, borrow pit, etc., these are not considered oil and gas activities by definition, and then would require rights holder engagement by policy, which is very similar to the consultation notification regulation. So in general, here's an outline of the consultation and notification or engagement processes. The first step is that the company intends to submit an application to the Commission. Then an invitation to consult or notification letter goes out. Then you would have the option to respond to the company or make a written submission to the Commission. Step 4 is generally a reply from the company and perhaps a meeting if there are concerns. The company will then summarize the consultation and notification results and submit the application to the Commission. So here's an example of the consultation and notification distances for oil and gas activities. So this is for pipelines, well sites, facilities. The regulation requires that either consultation or notification is done. And this depends on a few things like what the activity is and the distance between your property as a landowner and the activity itself. So for example, if there's a well site that's proposed for less than 9 wells and the amount of land needed is less than 5 hectares, then the consultation distance is 1,000 meters and the notification distance is 1,500 meters. For 9 wells or more and 5 hectares or more, so more land and more wells, the area increases to where the consultation distance is 1,300 meters and then the notification distance is 1,800 meters. So within those distances, who is consulted and who is notified? The consultation and notification regulation sets out who is required to be consulted and who is required to be notified. This includes landowners, First Nations reserves, nearby landowners, or rights holders. Determining this is based on proximity to the proposed activity, as well as other factors such as the presence of a residence or structure. So for example, if a person who owns land within the notification distance is required to receive a notification letter, and a person who owns land and has a residence or structure within the consultation distance is required to receive an invitation to consult. Rights holders are determined differently, so if the activity is proposed over an area where there are other tenures, the tenure holder is notified. Unless the activity will directly affect that person's tenured rights, then they are consulted. So when the Commission receives the application, we do check that everyone within this radius that should get CNN has gotten it. So what information will you receive? There are some differences between a consultation letter versus a notification letter. So the consultation letter is required to have a bit more information, such as foreseeable noise, dust, and odors, and along with an opportunity for you to request a meeting. However, they are similar in many ways, and both do offer an opportunity to engage. So some of the items that are included in both types of letters are contact information for the applicant, a description of the proposed activities, including a map, a description of the order in which the activities would be carried out, and 2 statements, one that you can provide a written response within 21 days or a written submission prior to a decision on the application. Either way, there is always an opportunity to respond to either the company or make a written submission to the Commission. If you are the landowner of the land where the activity is being proposed, before, during, or after you get this information, you will also be engaging with the company on a surface lease agreement, which is actually separate from this process. And as a landowner specifically, you would also be notified once a decision is made on an application. So as mentioned earlier, if the activity being proposed is not a well site, pipeline, or facility, it may be something like a campsite, water loading station, or borrow pit. These are not actual oil and gas activities themselves, but instead they're activities that do support them. So for these items, rather than through the consultation and notification regulation, rights holder engagement is done by policy. This picture does reference the regulation, however shows an example of a linear proposal through tenured areas. Very similar information is sent out, but instead of a radius with specific distances, you would get a letter if the proposed activity is within an area subject to your rights and if you were to be directly affected. One of the differences is that instead of the 21-day timeline for consultation and notification, engagement timelines are 14 calendar days for these associated oil and gas activities. So when you receive a consultation or notification letter, you might have questions or concerns about the project that's being proposed. So here are some examples of interests that are regulated by the Commission and others that are regulated by other agencies, such as the Surface Rights Board. We regulate aspects for activities such as hydraulic fracturing, flaring, noise, seismicity, spills, odor, water use, and things like traffic on public roads are regulated through the Ministry of Transportation and Infrastructure, and compensation is regulated through the Surface Rights Board. So for any concerns, a verbal conversation is always an option with the company and/or one of the liaisons at the Commission. However, you can also submit your concerns in writing. This is an important step if you want your concerns to be documented and included in the application review process. So to do this, there are two options, and these next few slides will explain what those are. So option one would be responding to the company. We do encourage this as a first step of engagement to see how concerns can be addressed between the landowner and the company before coming to the Commission. A written response should be specific to reasons why the activity should not be carried out or why it should be modified. Or if it's in response to an invitation to consult, you can also request a meeting in writing. For example, if a well site is planned to be drilled during a time or season that would impact your farming activities or maybe access to your fields, these are conversations that we recommend having either at this stage or early on in the process. So as soon as you are aware of the proposed activity, that way there's lots of time to have discussions, do field visits, and explore options to address these concerns. If a response is received by the company within 21 days, and if it sets out these reasons why the activity should not be carried out or should be modified, or if it requests a meeting, then the company is required to reply back in writing. This written reply must include a few things. It must include a description of any revisions, a description of the results of a meeting if one was held, and a statement advising that your written response and their written reply will be included in the application to the Commission. So this means that even if you don't contact the Commission directly, we will still be aware of these concerns if this correspondence does take place. The reply from the company would also need to include a statement that a written submission can still be made to the Commission. So after correspondence with the company, there still may be concerns that you would like to express to the Commission. So option two is that you can make a written submission. This is a letter addressed to the Commission about your concerns and can be made at any time before a decision is made, so there is no 21-day timeline on this. And a written submission simply means that you can send us something in writing about a proposed project. Written submissions are avenues for raising land use concerns or suggesting protective measures prior to a decision on an application. It is an opportunity to provide a description of how the proposed activity will directly affect you, and when possible, also provide a suggested approach to minimize any impacts and reduce concerns. So here are some options as to how to send us a written submission. You can send it either a letter in the mail, contact us through our website, or send an email. There are also forms available online, which can be mailed, faxed, or emailed. The form helps because there is some guidance on it, as well as spots for information that helps us to identify the project. Since many times we don't have an application when we get submissions, more information is helpful. So when we receive written submissions, the first step for us is to send a copy of it to the company, and this is something that's required under the Oil and Gas Activities Act. Our next step is to start gathering information about your concerns. We start working with you and the company to see what has been done to date and if or how any concerns can be addressed. We will always respond to written submissions. In this case, the company is not required to under regulation, like a written response. However, we do encourage it, especially if concerns are project specific and prior to an application. Once a written submission is received, it is required by the Oil and Gas Activities Act to be considered in the Commission making a decision on an application. So the third type of engagement you might receive is from the Water Sustainability Act. This act became effective in February 2016 and is primarily used by us for water licenses, short-term use applications, and amendments involving changes in and about a stream. The Commission processes these types of applications because the water would be used for oil and gas purposes. For the Water Sustainability Act, this does not follow the consultation and notification regulation, so it is a bit different. It does have its own set of notification requirements, and it is notification only. It's based on who would be affected rather than who is within a certain radius. So this includes those who already hold a license for water use, maybe for irrigation purposes. It includes riparian owners and those landowners whose property may be physically affected by a license or authorization. So the Water Sustainability Act uses the term objection. However, written submission forms can still be used for this as well. And unlike written submissions for oil and gas activities, objections to the WSA notifications have a timeline of 30 days to be sent into the Commission. If access across private property is required, part of the application is that the applicant must have landowner consent as well. So just to highlight some main points for the WSA notifications, information on the proposed water use will be sent out by notification. There is not a legislative process for a written response or written reply. However, there is an opportunity to submit an objection to the Commission within 30 days. Once a decision is made, anyone who sent in an objection would receive a notice of an authorization. And regarding water use, as part of the application review process, we are able to calculate how much water is available for permits to ensure environmental flow needs are met. If you are an existing water license holder, the Commission takes this into account as well in making a decision. And for more information on surface water, you can also see our other webinar at the link provided here. So more specifically, what does the Commission do with concerns? When liaisons become aware of a concern, we begin to gather information from both the stakeholder and the applicant, as well as from internal experts, depending on what the concern is. This may begin well before an application is submitted to the Commission, or when the consultation and notification report is submitted with the application and indicates unresolved concerns. Facilitation of dispute resolution may be as simple as prompting the exchange of additional information to providing neutral, interest-based mediation between the parties. Our Community Relations Department can also arrange for meetings to discuss your concerns that might include our subject matter experts, and/or we can do a site visit with you on your property. We do aim to fully understand your concerns and look at options on how they can be addressed. If you are a rights holder, so trapper, guide outfitter, for example, rights are generally not exclusive and there can be multiple licenses issued over the same land. It is expected that rights holders work together to minimize impacts to each other's interests as much as possible. And while this may result in there still being some outstanding concerns, written submissions are required as part of the Oil and Gas Activities Act to be considered in making a decision on the application. And we do want to be thorough and ensure that we have a full understanding of what those concerns are. This process does not halt the review of the application, but instead it continues in parallel with the application review process. So as mentioned, submitting your concerns in writing is important because it allows them to be included in the application review. If, however, this is not convenient for you or you're unable to do this, an option is to also have someone else represent you who can submit written concerns on your behalf. So to do this, the Commission needs to be satisfied that you have designated someone else to act for you. For example, this could mean that as a landowner, you want a neighbor or relative to represent you. Letters designating representation need to be addressed to the Commission, signed by the landowner, and should give direction on the parameters of the representation. For power of attorney, we would need a copy of that as there are specific parameters such as timelines as to when they are valid up until. So once we become aware of your concerns, how can we help? Again, we have 3 landowner liaisons that can speak to anyone who has concerns about oil and gas activity. We can meet in person to discuss and go over information received and see how any concerns can be addressed. We have a resource center at the Dawson Creek office and a variety of information resources that we can access. We can also help with inquiries for interests such as water use, application statuses, seismic events, and information in our e-library, such as well data and well reports. The Commission has a variety of departments that specialize in areas such as emergency response, environment, and seismicity. We can also reach out to other agencies regarding technical issues, for example, such as the location of a pipeline in proximity to things like utilities or power poles. So this has been a concern in the past, where we work to find out parameters and options for the location of a pipeline and how this affects the landowner's use of land. We are continuously involved in initiatives on topics that are in the public's interest. An example of this is the recent collaboration on a research project to install 30 new groundwater monitoring wells within the Peace Region area. We also work with other agencies and ministries to provide online data that measures things like air pollutants commonly associated with oil and gas activity. So how are your concerns considered? The decision-making process requires the Commission to consider a number of different factors and interests. So that includes written submissions, application information, and regulation requirements. And since concerns and submissions become part of the application review process, we are able to see how consultation has progressed. For example, we might see that you had expressed concerns to the company about project timing and how it would conflict with any farming operations. We may have also been involved in addressing these concerns if a written submission was made. So if there were outstanding concerns regarding access, for example, we can further inquire as to what options had been discussed and if there were any mitigation efforts made. Once an application review is completed and a permit is issued, it doesn't necessarily mean there haven't been any changes or revisions to an application based on concerns that were brought forward during this time. If there are changes prior to an application being submitted, there are other consultation and notification requirements depending on the significance of the change. And similarly to after a permit is issued, an amendment can be submitted which may incorporate some changes that address concerns as well. So in the process of considering concerns, the Commission works in a variety of ways to engage with landowners and those affected by oil and gas activities. We know that some rural areas have more oil and gas activity than others. So over the course of the last year, some of you might be aware that the Commission was part of a working group that heard concerns from the Farmington area, which is in northeast BC between Fort St. John and Dawson Creek. The Commission worked with the Peace River Regional District and local community members to gain valuable perspectives on living and working on land amongst oil and gas development, and the need for more conversations between landowners, industry, local government, and provincial regulators. So some of the outcomes from this working group were that we have recently updated our noise control guideline and have arranged for some community members to participate in a study regarding crop growth on pipeline rights-of-way. So what else are we doing? Some other concerns we've been hearing about in general are things like lighting, seismicity, and groundwater quality. These are all part of ongoing research and initiatives that the Commission is involved in. So to explain a little bit more detail about those specifically, regarding lighting, we have heard concerns that lighting from well sites or facilities was too bright for nearby residents, especially at night. So some changes were made by industry to address this, which have resulted in positive feedback from the local area. The Commission is also developing a lighting guideline that better describes what is meant by excessive lighting, which is the term used by legislation. For seismicity, in 2018, the Commission issued a special project order to address seismic events that happened from hydraulic fracturing in a ground motion monitoring area, which was designated as the Kiskatna Seismic Monitoring and Mitigation Area. The Commission understands the concerns with seismic events from fracking and continues to expand our research by installing additional seismic stations in the Peace area. There is a picture of one here on the far right of your screen, an example of one of the Commission seismic units. As data is collected and new stations are installed, the intent is to assess the data for regulatory enhancements if necessary. And to elaborate on the groundwater study, 30 new groundwater monitoring wells will be installed in the Peace area. This is being done to gather more information about groundwater conditions, including levels of methane and other hydrocarbons close to oil and gas wells. We want to be able to provide data that supports long-term sustainability and viability of oil and gas development, and to be able to address recommendations related to groundwater monitoring. So just to recap, we have covered these 3 types of engagement. If there are any questions as you find yourself going through one of these processes, we would be happy to speak with you about it, just for any clarification purposes. So I would like to point out this section of our website for further information. It's found in the public zone section. There is information on air quality, water use, seismicity, and online services for data such as well reports and activity levels. There's also interactive maps to use as well. And a good link to always check is our information bulletin section on our website under the publication section. New items are posted here, such as updates to the noise guideline, new seismic stations, and methane guidelines. You can also subscribe to these bulletins if you would like to receive them through email. We also have a section in our online resources where you can check the application status to see where it's at in the review process and if a decision has been made. This would be of interest to you if you're anticipating a decision on an application and want to see what the status is. For the future, please note that we will have a new look to our website coming in February 2020. It will still offer a lot of information, but will also be more user-friendly. So IMAP and our data portal both have some great information there if you want to look up a project by location. You can view them on a map, turn on different layers, and see them geographically. If you don't know the location, you can just zoom into the area that you would like to see, and you can view oil and gas activities in your area and what is around you. We also have a landowner information guide and a landowner frequently asked questions document on our website. These, I would suggest, are great starting points of learning about oil and gas activity and the consultation and notification process. The landowner guide also describes how to do a written response and make a submission to the Commission. So this inquiry flowchart is online as well and in our landowner information guide. It explains how to go about looking for information, requesting records, submitting concerns, and contacting the Commission about an odor or spill for any activities that are existing. And so we are accessible. Please know that we are here to answer any questions you might have about consultation and notification or how your concerns can be addressed. This concludes the presentation portion of the webinar. The main contact phone number here is for our Community Relations Department, where you can reach us. So thank you for joining again, and we will now go ahead into the question period. So at this time, we will mute for a couple of minutes to allow for any questions. So if there are any questions specific to consultation and notification, you can type them into the comments box, and those questions not addressed will be followed up with later on. So we're just going to mute the microphone for a couple of minutes. Hi everyone. So we do have a couple of questions. One of the questions is, does the BCOGC get involved when a project taking place in Alberta has an affected area with a radius that overlaps across the province line? So the answer to this is no. That would be under only Alberta's regulatory framework. So the Commission would not be a part of that process. And another question about the presentation, if it's going to be available on the web. A link to the presentation will be emailed to those who are registered, and the presentation will also be posted on the website tomorrow. So one question is that the slide referenced First Nations reserves rather than territories. What about traditional territories? So the engagement for First Nations is under the consultation and notification regulation portion for companies to engage with them that way. The Commission does have a separate process for First Nations engagement, and that is done internally by the Commission separately. So another question we have is, what mechanism is available for those that should be consulted but aren't? So when an application is submitted to the Commission, we can see who has been consulted or notified, and we also look at in the system to see who should be consulted or notified. So if we see that there's somebody that hasn't been, then we would request that to be done. And another question, are the regulations you note available for all to review? So yes, they are all online. There's the BC Laws website, and also on our website, there's a link at the top called legislation, and they're all under there as well. Okay, and one more question is there different rights for a First Nations trapper versus a non-First Nations trapper? So short answer is no, that there's not. Rights holders are considered rights holders, and the definition for that is outlined in the Consultation and Notification Regulation. We do have a couple more minutes if there's any more questions. So there's another question, does BCOGC have engagement model levels? We would need a bit more information on what your question is about. We can also get back to you as well with some information that we do have about consultation notification versus engagement. But if you could elaborate in the comments, we would be able to answer that. Okay, so the rest of the part of the question is, will BCOGC be willing to take on a shared engagement record, which allows both BCOGC and First Nations groups to speak closely to valued components? So the Commission does have an engagement process specific to First Nations. It is separate from the consultation notification regulation, which is done by the Community Relations Group. So those are separate processes. Okay, everyone. Well, thank you for joining the webinar today. We will get back to any questions that we haven't got back to yet. And there is a frequently asked questions document on our website as well, if you'd like to take a look at that. And once again, thank you and have a good rest of your day.